without further ado, you can just accept on your side. So formally, good morning, everybody. Welcome to our October webinar. Thank you for joining us. I'm very excited with our speaker that we have today. Carl is just going to do a couple of announcements for us. And then after that, we're going to hand over to Rosine, and Rosine will do a bit of an intro to our esteemed guest today. And then we'll hand over to Marlon. Carl, the floor is yours.
Thanks, Linda. Good morning, everyone. I hope you're all doing well, and thank you so much for tuning in to our webinar today. Then just a few marketing announcements. As Linda said, this is going to be recorded and it will be published on our YouTube channel and website. So please remember to like and subscribe to us. And then if you haven't already, please do also subscribe to our newsletter. So this way you can keep in touch with the TVDM consultants team. Then TVDM Table Talks, our live discussion, will be happening Friday, the 25th of October at 9 a.m. Please also note that this feature is only available to paid for members, and if you'd like to upgrade, then please reach out. I'll put my email address in the chat. And yeah, that's all the announcements I have for today. So I'll hand over to Rosine to introduce our speaker.
Good morning, everyone. Hope you're well. Super excited about this one. Marlon Shevelew is a practicing attorney with over 24 years of experience and the director of Marlon Shevelew and Associates in Cape Town. They're attorneys, notaries, and conveyancers. He holds a BA LLB from the University of Cape Town and began his legal career at Asheson's Attorneys in Cape Town, progressing from article clerk to professional assistant and eventually equity partner. In 2005, Marlon founded his own practice, specializing in property, commercial, contract, and compliance law, and he has since earned a reputation for excellence, receiving multiple awards in these fields. Marlon is also a respected facilitator and educator, regularly contributing as a guest rental property expert on Cape Talk 567. He has won over 60 international awards for his expertise in rental property law. He's the original author of PayProp's rental documentation and the TPN lease fact, and currently serves as the author of Reconnect You's rental documentation. Marlon is also a preferred referral property attorney to the Rental Housing Tribunal in the Western Cape. Furthermore, Marlon was invited to write a book on rental property law by Juta and to edit the Butterworth's forms and precedents on rental property law for LexisNexis. He has also been invited by the Law Society of South Africa on 3 occasions to lecture and train candidate attorneys and attorneys on rental property law. And that's Marlon.
Gee whiskers, Marlon, you're even more esteemed than I thought. Now I'm even more fortunate. Gee whiskers. Marlon, over to you. Thank you so much.
Thanks, Linda. Thanks, Carl. Thanks, Rosine. That's a lovely introduction. I don't know who wrote that, but sure, very impressive. You know, I was on Cape Talk yesterday with Wendy Nola and Pippa Hudson, and we're discussing the ridiculous situation of a landlord whose property has been hijacked by a tenant and all the different legislation applicable and the costs involved. And I said to myself, well, that's just a basic landlord-tenant relationship. Can you imagine what we are facing when you're dealing with the landlord-tenant dynamics in community schemes? And it's always been something that's been of interest to me, because I said to myself, in the normal dynamic, you've got a landlord, a tenant, and potentially a rental agent. But transplant that into a homeowners association or a body corporate. In those types of community schemes, there are more role players, and they are, as I said, more dynamic. So it's a really interesting topic. And I think what is important is that I'm just going to localize it to the rental aspect. You know, one can get carried away with resolutions and quorums and the whole sexual title aspect, but I'm looking at the dynamics vis-a-vis landlord-tenant and the obligations that fall upon landlords when they are dealing with a tenant in a community scheme, and similarly the duties of tenants to acknowledge that it's not just house rules anymore, but it's the communal rules that they need to abide with. I've also got 1 or 2 jokes I'm going to throw in, because people say I am a part-time comedian. I always respond, well, if you're going to stand up in the court and argue these days, you need to be a bit of a comedian, and you need to have a bit of a sense of humor, because boy, are we dealing with a lot of nonsense these days. But before I begin and share my screen and become small and in the corner, I just want to give a shout out to Zelinda. Zelinda and I have worked together for a while now on a number of matters, and I'm truly indebted to her for firstly bringing me into today's webinar, to TVDM to actually giving me an opportunity to work with them and to coalesce with them, especially when a matter goes from CSOS to something more sinister. And that's where I basically jump on the bandwagon from a litigation perspective. I'm a facilitator, I'm a mediator, but I don't do that at CSOS. I apply my trade in the courts. So ultimately, CSOS matters may end up in courts. That's where you'll find me. But those matters which involve initial disputes, Zelinda is always my first port of call to refer her to. And I'm really glad to have the opportunity to share and give back a little bit today. So without further ado, let's share the screen and see what we're talking about today.
Awesome. Thanks, Marlon.
Sure. Okay, can everybody see that? I'm not very good with Zoom.
No, you've got it. I don't know if you
Okay.
want to put it onto a slideshow presentation mode, or if you're happy to leave it like that. Up to you.
Perfect.
Here
Is
we
that
go.
better?
Perfect. Got it. 100%.
So we're just discussing landlord-tenant dynamics in bodies, corporate and homeowners associations. And I was actually just, before we even started, I was chatting with Zelinda this morning in the car, where I picked up this incredible anomaly. And we're not going to talk about it today, but I just want to point out to you how these kind of issues can just meander into totally different idiosyncratic situations. So, for example, when you are having a body corporate leasing to a common area to an owner or an occupier, that of course is regulated in terms of the STMSA. And a unit, for example, or a storeroom or a parking space, hypothetically, can be leased by the body corporate. We know that in terms of a special resolution. And what's incredible is that the parking space in itself is defined as part of a dwelling in terms of the Rental Housing Act. So whereas I'm going to be talking about today about the legal connection between a body corporate and a tenant, or an HOA and a tenant, and that it doesn't actually exist, here I am debunking my whole theory by telling you that it may very well be a nexus between a body corporate and a tenant in evicting a tenant who's occupying a parking space, because the parking space is deemed to be part of a dwelling in terms of the dwelling definition in the Rental Housing Act. So that's just to pepper this already with some very weird situations. So for our purposes, when we talk about managing rental properties within community schemes, such as sectional titles and HOAs, we are dealing with challenges that extend far beyond the freehold properties, the freestanding properties. So on the one hand, you've got a landlord and you've got a tenant and potentially a rental agent, unless you're a masochist and you want to manage the property yourself. But in sectional title complexes, you've got the landlord, the tenant, potentially a rental agent, potentially a sectional title agent, the trustees, governance. So effectively, you've got a whole myriad of role players. And ultimately, you may find that there's a dichotomy between the rental agent and the sectional title agent, and the rules that apply or the rules that don't apply. I mean, a lease agreement where the tenant has an obligation to follow those terms and conditions, and yet there are extraneous rules, communal rules, shared space rules that are incorporated by reference into the lease agreement. And suddenly you've got a multitude of different things which shouldn't contradict each other, whereas with the normal freehold, there's my lease, there's my house rules, you don't like it, leave. So I think it's not dissimilar to a franchise where you've got a franchisee who thinks they are the independent, owners of a restaurant, but they're not. There's the central kitchen, there are royalties to pay, and they are bound to act in terms of the franchisor's obligations. And not dissimilar.
Recipes to follow, hey, Marlon?
100%, it's food for thought, as they would say. So it's just an incredible situation where an owner of a unit in a communal scheme needs to be alive to the fact that there's lots of moving parts which they need to understand. So hopefully this presentation sheds some light in it. And of course, if there are questions which are very sectional title orientated, I'm always happy to enjoin Zelinda to pop in with some answers, because she's a world of knowledge. And again, I'm thrilled just to be able to share the platform with her. So in essence, when you're dealing with freestanding property, you've got the landlord-tenant relationship, which of course is governed by a lease agreement and house rules if it's applicable. And it's the landlord, of course, who is in control of those rules, sets the regulations, provides the lease agreement. Presumably, they are all legal and not what we call mala fides or contra bonus mores, not against the law. A very simple situation, one would think. But then again, when you look at sectional title schemes, such as the body corporate or an HOA, then invariably you've got the conduct rules that are attached to the lease, in terms of the body corporate, and you've got estate rules that are attached in terms of the HOA. And ultimately what that does is it enjoins more terms, more obligations, and a greater duty, I would say, of the landlord to ensure that the tenant understands the veracity of what they're doing. And I'm also going to show you just now some really interesting things that develop between the Rental Housing Act and other legislation, and how actually landlords may be empowered somewhat more in terms of taking action against their tenants just by maybe introducing certain clauses into their lease agreement, or alternatively bringing in those rules and making sure those rules truly apply to the landlord-tenant situation. So what is important to also remember is that the body corporate can't effectively enforce directly those lease terms with tenants. So bodies corporate and HOAs are not linked to the tenant per se. Their link is with the owner, and the owner's link is with the tenant. There's no direct link per se between a body corporate or an HOA with a tenant. And we're talking in terms of the traditional landlord-tenant relationship, not the leasing of common areas. So I just want to put that out there. And there's a duty on the landlords to ensure that those tenants understand and appreciate what those rules mean together with the lease terms. Because obviously the lease terms regulate the unit the tenant resides in, and that in itself incorporates the Rental Housing Act, the PI Act, CPA, maybe a little bit of the National Credit Act, and lots of other factors. But once you bring that and you transplant it into a community scheme, the additional aspects of the body corporate rules, the estate rules, which may be very varied and very detailed, depending on the nature of the complex that unit is in, that they need to abide with. And why do they need to do that? Because it's always the flipping owner of the unit that is on the line when it comes to fines, when it comes to sanctions. And ultimately, they may have a right to pass those fines, to pass those sanctions onto the tenant, but landlords are always in the firing line when it comes to problems of the tenants affecting the complex as a whole. So in community schemes, the body corporate holds landlords accountable for tenant behavior. And of course, if the tenants don't follow the scheme rules, don't follow the conduct rules, don't follow the estate rules, the body corporate or the HOA doesn't have a direct link to the tenant. They go after the owner, and similarly, the landlord, being liable for those fines, has what we would call a reversionary right to push that onto the tenant. But of course, the lease agreement needs to provide for that. So you've got to make very sure in terms of your lease agreements that there are clauses in the lease agreement that hold those tenants liable for any fines or any penalties that may be applicable. And that is effectively done, is it not, when those house rules or those conduct rules or those estate rules are attached to the lease agreement.
Yeah, Marlon, could I jump in there for 1 second? So what we do, and it's something that the CSOS requires, although not officially, when we draft a fining rule in either an estate or a body corporate, we actually allow the body corporate, the trustees or the directors, to invite the tenant or occupier to a disciplinary meeting. So if there obviously has to be an opportunity for the alleged offender to meet with the management that is enforcing the fines. And because very often the fine has been enforced because of the conduct of a tenant, we do allow that tenant to attend the meeting, because they might say, oh, you gave me a fine for a barking dog, but I don't even have a dog, I've got a cat, or whatever the situation might be. So just a little bit of a note there. And that type of conduct rule is approved by the CSOS. So it allows that, not relationship per se, but at least an invitation to the tenant.
I love that. And that's part of the education process, because being in a complex, there would be a duty to educate those tenants. I think a lot of the lack of education of tenants manifests itself in complexes. With a landlord-tenant relationship in a freestanding property, it's very simple. But obviously, they're not alive to the fact that those conduct rules don't just apply to the owner, they apply to themselves as well. And I think being invited to that kind of thing, especially if you've got a cat and there's a barking dog. I mean, if your cat is barking, I would like to attend that session myself.
That's a whole other issue.
Yeah, but that's the cat's out of the bag. We can move on. So it's so important to do. And again, just violations such as noise, waste disposal, misuse of the common area. The landlord needs to take financial control, because invariably he's in the firing line, as I mentioned. So he needs to educate those tenants. And as you say, you know, what CSOS has approved now, it all starts with the lease agreement, and it starts with who you're putting into the property. Does the tenant know all the scheme rules. And it's so vital to know that, because you don't want to be a pariah as an owner in a complex where they say you're putting all these tenants in, and these tenants aren't aware, and they are slaughtering animals in the living room and playing music beyond 12 o'clock at night. And, it disrupts the entire complex, and that's the last thing you need to do. Freestanding, you may be annoying one or two neighbors, but in a complex, presumably you're annoying a lot more. So again, repeated tenant violations lead to fines. Landlords must resolve this with the tenant. Obviously, that causes a strain vis-a-vis your own tenant, notwithstanding your problems with the complex. And as I say, it's so far simpler when it comes to a freestanding property, just with regard to a landlord and a tenant. And in as much as you've got a landlord and a tenant who have a lease agreement, you've got a landlord and a rental agent who have a mandate. And not dissimilar to that, you've got a body corporate which has a contractual relationship with the owner, and the owner has a contractual relationship with the tenant, but there's no contractual relationship between the body corporate or the homeowner and the tenant. And that's where the problem comes in. And any bodies corporate or any people involved in the scheme who believe they have a right to act against the tenant or to force an owner to act against the tenant will be horribly mistaken. And we'll get to that just now. So obviously you've just mentioned, Zelinda, and I won't go into too much detail about CSOS. I mean, I can't think of a time when there wasn't CSOS, but I think it plays an important role with regard to resolving disputes. And as I mentioned, tenants or landlords and the body corporate itself have the ability to deal with disputes at CSOS. And of course, if CSOS decisions are made, they can be appealed to the High Court, or you can just go to the High Court yourself, and I'll happily make myself available. Although CSOS certainly plays a role in dealing with disputes, and in fact, are the first port of call for a number of disputes that doesn't need to become litigious. I suppose once you become litigious, it's a whole different ballgame. I think also what's important to remember in the traditional freestanding landlord-tenant relationship, there's no CSOS. You've got the Rental Housing Tribunal, and it has to be a residential property that comes before the Rental Housing Tribunal, and the residential properties are in terms of the Rental Housing Act. So it's a bit of a weird one where you've got a residential property in a complex, and it's a dispute between a landlord and a tenant. Are you going to the tribunal? Are you going to CSOS? As I said, you've got to correctly choose your forum, Zelinda. I suppose you would agree with that.
100% agree with you. Yeah, the CSOS doesn't deal with everything, we know that. And there is a place for court, there is a place for homeowners associations arbitration. We mustn't forget about it. And I was just popping into the chat as well, Marlon, that we always have to first exhaust our internal remedies of internal dispute resolution.
Absolutely.
As well.
Absolutely. So, again, just to touch base that where it starts is the attachment of the lease of the conduct rules or the estate rules or the house rules to the lease agreement. And again, the tenant must understand that, as we've already mentioned. And I think just education will help a lot in that regard. And that's why I just want to touch base on what the Rental Housing Act says. And this is dealing with freestanding properties, and it continues to blow my mind, and it's an anomaly that I pick up. I mean, just to put it out there, Rental Housing Act is my Bible. Zelinda's got a far greater Bible, in fact, a couple of Bibles. I'm not going to say it's the New Testament, but it's certainly something that is biblical in nature, I would say. And the Rental Housing Act is a small act. It's subject to amendments. The 2014 amendment to the Rental Housing Act is 10 years in waiting.
Sure.
Yeah, no, it's crazy. And we don't even have a national set of housing regulations. The national set of rental housing regulations from 2008 was never brought about. So now we have different bylaws in different provinces. So it's a bit crazy. But the point I want to make is that in the Rental Housing Act, and this is important for sectional title schemes as well, because it's synonymous. It says a copy of any house rules applicable to a dwelling must be attached as an annexure to the lease. That means the conduct rules. That means the estate rules. They must be attached to the lease agreement. That's what the Rental Housing Act says. And it also says in section 5, subsection 9, that a landlord must ensure that that is done. In other words, they must ensure that those rules are attached. There's not any defense to say, well, I didn't do it. It must be attached. And there's value to attaching it, as I'll discuss just now. But what absolutely floors me is that it says, in terms of section 16 of the Rental Housing Act, this is actually an amendment in 2007. There's been the 99 Act, the 2007 amendment, which came about in 2008, and then there's a 2014 amendment, which hasn't come in yet. The 2007 amendment says, if you fail to comply, in other words, if you do not attach the rules to your lease agreement, you are committing a criminal offense, which means you can go to jail,
That's
or you
insane.
can be fined 20,000 Rand, or both.
Shocking.
Now, imagine going to jail, right, for not attaching the conduct rules or the estate rules. At least in that respect, you'll have involvement in a gated community. See, that's my joke.
Yeah.
So I was waiting to build in that joke.
Oh,
So
good one.
and you'll have a captive audience as well to
Yeah.
discuss your issues with.
You'll
So,
always have quorum, hey?
oh wait, absolutely. So it's incredible to think that, and people ignore this, you can actually be arrested for not attaching the conduct rules to the lease agreement. I've never seen it happen in 24 years of experience, but I'm not one to say that it can't happen. And then something which is very interesting, which maybe many people who manage complexes don't know, which is the Consumer Protection Act. And this is something I'm going to explain very carefully to see if it makes sense to you. So the Consumer Protection Act basically allows for a landlord to terminate a lease agreement by giving them 20 business days notice to remedy a breach. So in terms of South African law, you have a natural person tenant in your unit in a body corporate. If that tenant doesn't pay their rental on time, the landlord has the ability to terminate that lease, but only by giving them 20 business days notice. They can't just summarily terminate it. That would be a breach on themselves and give the tenant plenty rights. But if they have to give them, if they want to put them to terms, they give them 20 business days. And if the tenant doesn't pay by the 20th business day, you can cancel the lease because non-payment of rental is deemed to be a material breach. Now, you can sue them after 7 days for non-payment. You just can't cancel until they have not paid by the 20th business day. Why is that important? Well, what's important is that if you look at a lease agreement as it is, there are only so many terms which are material terms. Non-payment of rental is one of them. I think maybe over-occupying might be another. It depends on the nature of the lease agreement. But the beauty is by attaching your conduct rules, by attaching your estate rules, you are bringing in additional terms, additional conditions into the lease agreement and creating more and more material terms that gives the landlord the right to terminate the lease if they don't remedy a breach. So, in other words, if you don't have the conduct rules attached, you don't have the estate rules attached, and one of the conduct or estate rules is that the tenant may not, use the Braai communal area after 10 o'clock at night. If that is not attached to the lease agreement, it's not deemed to be a breach of the lease. It might be a breach of the conduct rules, but it doesn't give the landlord the opportunity to rely on that particular breach for his own purposes to cancel a lease agreement. I hope that makes sense. And it's important to understand that because you want to be, as a landlord, to be in the strongest position possible to be able to cancel a lease agreement based on a breach, especially if you've got tremendous pressure being placed upon you. Don't forget the body corporate or the homeowners association can't force an owner to evict their own tenant. They can apply a lot of pressure on it and they can fine and sanction. And Zelinda and I will tell you, we've worked on a number of matters where there are fines after fines after fines. And the infuriating situation where the body corporate can't do anything to that tenant but for that. But if the landlord has enough pressure on him and enough rules and regulations to rely upon, it just makes the process more easier. So it's just important to know that that's how this filters in with the Consumer Protection Act, especially since you can only terminate a lease if there's a material breach that isn't remedied. On that point, I don't know if you know this, but if there isn't a material breach, Zelinda, I don't know if you have any perception as to material breaches in a complex scheme, but what is a material breach? Non-payment of rental. A non-material breach might be the fact that they play music after 10 o'clock at night.
Yeah.
It's a breach, but it's not a material breach. If it's not a material breach, you can't cancel the lease agreement. All you can do is force them to comply by way of what we call specific performance and maybe sue them for damages. So there really are so many limitations arising out of the Rental Housing Act. If you are transplanting a landlord-tenant relationship into a community scheme, make sure that your tenant understands everything, what they can and cannot do, have an education session with them, and maybe even get the body corporate or the homeowner association to educate the landlord as to what their responsibilities are if their tenants misbehave. So, as I said, it all comes down to communication. And this is something that blows my mind if you're ready to have that this early in the webinar. So the Rental Housing Act, ladies and gentlemen, and I'm not making this up, clearly says that a lease agreement does not need to be in writing. Okay? Unless it is subject to the provision of formalities in respect of Land Act, leases of Land Act. That basically means if it is a long lease, a 10-year lease endorsed against the title deed, a notarial lease agreement, and of course, when it talks about community schemes, leasing, common areas, we fall within that terrain. But how's this logic? It is a criminal offence if you don't attach the conduct rules or the house rules or the estate rules to the lease. But it's not necessary to have the lease in writing.
Doesn't make any sense to me at all.
How do you attach those documents to an oral?
Exactly.
Exactly. Just an anomaly I picked up in the Rental Housing Act. There are a number of anomalies in truth, and regretfully, the Rental Housing Amendment Act does not cure those defects. Another perfect example is if a landlord is very unhappy with a tenant, or let's just say it says in the Rental Housing Act and the bylaw regulations, the landlord is entitled to have reasonable access to the property, to inspect the property. And it's agreed, and it says in the bylaws, if the tenant doesn't allow a landlord in a community scheme, wherever, to have access to the property, because let's say the community scheme, the body corporate, the trustees, the sectional title agents, the managing agents are very unhappy with the actions of a tenant. They say to the owner, go and check up on your tenant, see what the hell he's doing after 12 o'clock at night. That tenant, can turn around and say, I'm not letting you into the property. Now, the landlord can say, yeah, but the Rental Housing Act says it's an unfair rental practice if you don't let me in. Correct. But there is nothing in the Rental Housing Act that tells a landlord what he can do about it if there is no compliance. He has to go to the High Court for an interdict to gain access to his property. So the Rental Housing Act as it is falls very flat. They talk hugely about rights and regulations and the duties of tenants and the duties of landlords, but invariably it's a very toothless piece of legislation when it comes to it. And that, of course, brings with it the PI Act. And we all know that because bodies corporate and HOAs can't evict tenants because there's no contractual nexus. You can only evict a tenant if you are the owner of the property or the person in charge. And I think that possibly, and Zelinda, you must correct me, is possibly the most frustrating situation where you've got an errant tenant, an apathetic landlord, yes, and a body corporate who is suffering. The entire complex is suffering at the hands of a tenant, and they can't act against that tenant.
Can I tell you, Marlon, that generally the landlord is not wanting to upset the tenant because they don't want the tenant to feel frustrated and move out, and then they lose the rental. So they will rather refuse to deal with the body corporates on the risk of losing their rental. It's only when their rental is at risk, in other words, not being paid, or the body corporate hasn't undertaken maintenance or remedial work, that they suddenly start threatening the body corporates to become involved in that. It's always got to do with the rental issue. Just on that note, Marlon, I've also put in the chat your website of 10 Risk, and if you've got a couple of minutes just to give some information on that. Yes. Because 9 times out of 10, probably 9.5 times out of 10, a body corporate's insurance cover doesn't have provision for loss of rental or alternative accommodation. I know that Mike Addison is on the call as well from AdShare, and he can maybe weigh in at the end about this insurance. But we're seeing more and more applications made to the CSOS where the owner is threatening or making application against the body corporate for loss of rental income or alternative accommodation. And the CSOS have made it clear that it's not within their jurisdiction to award a loss of rental income, but perhaps that's something that you can touch on as well.
Absolutely. I mean, I'd love to do that.
One other thing
as well.
No problem. And then one other thing is access to a scheme. I've seen more often, unfortunately, that bodies, corporates, and sometimes homeowners associations prohibit an owner from accessing the scheme if there is a tenant. So they say that the rights of use of common property have been transferred to the tenant. So as an owner, I shouldn't get an access tag. As an owner, I shouldn't be on the biometric system because my tenant is there. So when there is an instance of the owner actually needing to go and view the units, or get the sheriff on site to serve eviction papers or whatever it might be, the owner can't even access the scheme. I mean, it's ridiculous.
No, that is ridiculous. I mean, it's not dissimilar to an owner having 2 sets of keys, as long as it's given on reasonable notice. The biometrics have totally messed up everything, in truth. Again, it's also deemed to be, as you know, we had a recent matter where, Zelinda, you and I, where it's deemed to be an act of spoliation, whereby if the biometrics are changed to preclude a tenant from coming in. But I do believe that it could be a similar type of application if an owner is deprived of access to their own property. I've never known anything like it, really.
Definitely.
But I'm going to make a note to discuss Tenris, because I'm very excited about this product that I've been endorsing for the past 8 or 9 months. But just moving on, it's just also very important that in terms of the STMSA, that tenants are not obviously members of the body corporate. They've got to adhere to these rules. They must know exactly what they need to do with regard to parking, noise, and pets. We all know as well that the body corporate must be apprised of changes to potential tenants who are there. And of course, as previously mentioned, not only does the Rental Housing Act prescribe that the rules must be attached to the lease agreement, Section 10(6)(c) of the STMSA also provides that the details of those tenants must be made known to the body corporate. So there's a commixture, so to speak, of legislation in that regard. And I also did, having chatted to Zelinda about this, touched on short-term letting. In fact, Zelinda wrote a lovely article, I think several years ago in 2017, about short-term letting. And yes, that's dealing with tenants on a short-term basis. And in that instance, there's not really a formal lease per se. And it's also a question whether or not those house rules need to be attached. You know, the bottom line is that the Rental Housing Act has applicability to a dwelling. Is short-term letting within the realm of dwelling? No, I would say it's more a commercial transaction. So no house rules per se, but there would certainly be a duty to ensure that the rules and regulations of a complex for short-term letting purposes are brought to the attention of the tenant. And then you raised a very interesting point in our discussion yesterday, Zelinda, about bookings made for same-day occupancy. You know, somebody's corporate addresses by having concierges or rental pools to manage. I think what's so important is, in whichever way you look at it, if you've got an occupant of a unit in a complex, those occupants need to know what to do, when to leave, and understand the veracity of staying in a complex. Because some people have short stays in complexes, some people have long-term leases, some are, you know, owner occupied. And I think one needs to be mindful of the whole communal aspect in that regard. And then must trustees, you know, engage with tenants in disputes? And I think, again, very, very important that the primary legal obligations are towards unit owners. So again, when it comes to a hierarchy, you've got trustees and you've got owners that they deal with. You've got owners who deal with the tenants. And do the trustees engage with tenants? Well, it depends, maybe on some occasions. But I think what's very important is that, as per Section 10(4) of the STSMA, that the rules apply to both owners and occupiers. Therefore, trustees may engage the owner regarding the tenant violations. But ultimately, it falls upon the owner of that unit to educate that tenant on what they need to do and what they need to follow to keep the harmony in the complex. And I think the larger the complex, the larger the potentially the larger the problems. I was actually at a block of flats in Sea Point the other day, Bordeaux. I don't know if you know Bordeaux in Sea Point.
Yeah.
My wife actually, she's an architect, just dropping that there. She renovated a flat in Bordeaux, and she was so impressed by the body corporate about when contractors could come in, when things would need to stop. It's such a stringent body corporate there, and it's managed by Trafalgar. And she just said she was absolutely blown away because even the builders had to come in at a certain time, leave at a certain time. It was strictly regulated. There were people walking around. They're not Karens. They were walking around just sussing out what's going on. And I thought, oh, that's what you're paying your levies for. That's what you want. And I think it's really, really nice to see that kind of regulated body corporate. Obviously not too regulated. You want to have some freedom. But I think with a very large complex per se, you need to have that kind of control. And just touching on a little bit of case law, it's a case of Vuljay. I love that. Vuljay Investments versus Bryanston Crescent. It was basically held there in that case, in the old Transvaal as it was in 1984, that the relationship between the body corporate and its individual members is contractual, and the rules form an agreement between the owners and the body corporate, just driving home the point. The body corporate deals directly with owners, not with tenants. And in short, trustees are not required to engage directly with tenants in disputes, but they may do so through the unit owner. And there are a couple of questions that Zelinda, you raised with me, and hopefully my answers are correct. If not, you're welcome to correct me. Can the body corporate fine a tenant? The bottom line is they fine the owners for rule violations. They can't fine tenants directly, but of course, the owners who are fined can seek retribution from their tenants and basically add those fines onto the rental statement. And it's important to have clauses in your lease agreements, and of course, I'm happy to help with that. I've drafted probably 3,000 leases in the last 24 years, whereby you ensure that because those house rules, those body corporate rules, those estate rules are part and parcel of the lease agreement, the breach clause has applicability to that. So if the tenant makes a noise and there's a fine imposed, that fine becomes the liability of the tenant. Doesn't mean that the owner mustn't pay that fine. He must, but he will seek repayment from the tenant. And as for vetoing a tenant, it doesn't give the SMA doesn't give bodies corporate the authority to veto tenants unless it's specifically provided for in the scheme's rules. So then if I could just maybe just bring you in there on that respect. We also were mentioning about putting certain rules in about vetting. I mean, I'm always curious about the ability of a body corporate to vet a tenant that I'm putting into a property, but it is something that can be done in terms of the rules.
So no, we do see rules very, very often that does have some type of veto rights. Either the body corporate wants to see the lease agreement prior to it being entered into, or the body corporate wants to have a meeting with the tenant. I've got no issue with the body corporate saying when your occupier or tenant moves in, you need to meet with the manager or the building manager or whatever to go through the rules, to sign a copy of the rules, to sign up to the access control, all those fun things. But a body corporate can't say yay or nay to a tenant. A body corporate can have a rule in place regulating the duration of the lease agreement, which is very often the reason for requesting a copy of the lease agreement. And then I often see bodies corporates trying to force the owner to use a certain platform or rental agent, which is also a no-no.
Yeah, I mean, that is just choice of suppliers in terms of the CPA. The reason why I mentioned is I was putting you on the spot there. I'm sorry about that.
No worries.
It's because if hypothetically, just think of it hypothetically, because I try to be as practical as I can, that if a landlord doesn't do their due diligence and places a tenant in a property, which hypothetically is the worst tenant in the world, because the body corporate doesn't have the power to veto a tenant, the body corporate, however, certainly would have a cause of action against that landlord for not doing his job in placing a proper tenant. So if that tenant causes damages, you may very well find that there's a damages claim from the body corporate against that owner by virtue of the fact that he didn't place a proper tenant.
Correct.
Not dissimilar to a landlord having an action against his rental agent who doesn't vet a tenant that he puts into his own property. Because in terms of Section 54 and 55 of the Consumer Protection Act, there is always a duty of a service provider to do a due diligence and to do a great job. And I don't care whether it's a body corporate or not, which isn't really linked so much to the CPA, but a rental agent is a supplier of services to a landlord and a supplier of goods to the tenant. And there is a duty of care. And I'd encourage those listening today to check out Section 54 of the Consumer Protection Act, which talks about the duties of a service provider. A sectional title agent is a service provider. A rental agent is a service provider. But again, can an HA refuse tenant access if a lease is terminated? Well, in my respect, they can actually do that. They may refuse access to a tenant as long as that lease has been lawfully terminated, because effectively there's no right for a tenant to be on that property. And it's the case of Shaftesbury sectional title, where the court recognized that sectional title schemes must be able to enforce their rules, even to the extent of depriving owners or occupiers of access in the case of persistent non-compliance. So you can refuse access to a tenant whose lease agreement is terminated, provided it adheres to fair procedures. Obviously, we're not talking about spoliation here. We're talking about a tenant that has left the property. If a tenant is still in possession of the property, as we all know, you can't simply deny that tenant access, because that would amount to an act of spoliation. And that was the interesting thing which we had, I was again on Cape Talk, where a tenant was deprived access to a property because the landlord had not paid his levies. It was the most unbelievable situation, and there was a naming and shaming of the agency. I jumped on board and the tenant was given access immediately. So I just think whenever a HOA or a body corporate is faced with a situation, speak to your lawyer, speak to Zelinda, just get an inkling as to what the situation is, because the minute you seek to deprive somebody of access to a property, it falls within potential illegal realm. So that's what I'm saying. I'm just saying be very careful about it. This was a case from 2003. And they simply say if you're going to deprive somebody of access, it's got to be legal, can't be unlawful. There's got to be good reasons for it, and it's got to be able to stand up in a court of law.
Marlon, just from a practical example, when I was managing properties, I once got that request from an owner to deactivate a tenant's access control as they had been evicted. And I chatted to my managing director at the time, and he suggested that I ask for a copy of the eviction order. And when that wasn't able to be provided, we refused to deactivate the access. And it turns out that it was simply a dispute between the landlord and the tenant, and there hadn't been a proper eviction. So I do think that it would be within the HOA or the body corporate's right to not just act on the written request of an owner, but to actually ask for proof. Otherwise, the body corporate or the HOA could be opening themselves up for a potential spoliation action by the tenant.
I mean, if I was the tenant's attorney and there was no eviction order per se, I would bring the spoliation application and I would join that particular scheme to the application and seek costs jointly and severally against the owner and against the community scheme. Absolutely. And then, of course, the PI Act. And the PI Act is the Prevention of Illegal Eviction from and Unlawful Occupation of Land Act. Whew, the PI Act. And that is applicable no matter where the landlord and tenant are based. So whether it's freestanding or whether it is in a community scheme, such as an HOA or a body corporate, if there is going to be an eviction, it needs to be by a person who owns the property or a person in charge of the property. That's Section 4.1 of the PI Act. It says, notwithstanding anything to the contrary contained in any law or the common law, or in my opinion, in any rules, the provisions of the section is that the owner is the registered owner of the land. The person in charge in turn means a person who has, or at the relevant time, had legal authority to give permission to a person to enter or reside upon the property. So in other words, if you've got an unruly tenant in a freestanding property or in a sectional title scheme, community scheme as you call it, the only way to evict them is by a person who has the authority to do that, the locus standi to do that. That is not the body corporate, that is not the HOA, it is the owner of the property. And the owner can't even be enforced to evict that tenant because there's no basis in law. There's no legal connection, there's no contractual connection, as I said, between the body corporate and the tenant. So it's a very difficult situation. And again, going back to a matter that Zelinda and I have, we won't mention which body corporate it is, but you've got this owner, I think you know which one I mean, Zelinda. These tenants are ruffians, they play music to all hours of the night, they have these proclivities for drugs and whatnot, and there's fine after fine after fine after fine, but what the landlord is earning off this tenant, or alternatively what the tenants are earning business-wise, the fine is a drop in the ocean to pay. We've had to wait for the landlord to take legal action against the tenant. We obviously in the background, and maybe I need to follow up on instructions about the exclusive use area that is being used, but the bottom line is it's entirely upon the landlord to evict that tenant. If the landlord doesn't do so, our hands are pretty tied, and that's just something that I struggle with, in truth. I was actually chatting with my good friend Chris van Geens, who's also a sectional title lawyer, and we've worked together for 20 years, and I said it just doesn't make sense that you've got landlords who have the power to determine whether or not to evict a tenant, even though they're fully aware of the breaches of the common law, of the rules and of the law, and how a body corporate doesn't have any power to go after that tenant. It's just such an anomaly for me. So just as we bring it to a close, no contractual nexus, as I mentioned a few times. There can't be an obligation placed on the unit owner to evict their own tenant. Homeowners, of course, and bodies corporate can assist the owner by giving them all the information that they need in order to proceed with an eviction. But that's pretty much the extent of it. So before I just reach the conclusion, let me just touch base now with 10 risk, if I may, and then I'll open the.
Please do.
So my law firm attends to about 30 evictions a month, and that's not a joke. We are 6 lawyers, and we've been operating for 19 years. And I've always looked, and I've represented a number of companies that offer rental protection. And about a year ago, I saw 10 risk, and I've known of 10 risk. I think I was working with 10 risk years ago under different ownership. And there's a certain gentleman named Rudolf Pretorius, who is now the head of Moirifia Brokers, which are the exclusive brokers for the 10 risk product underwritten by Infinity Insurance. And what they basically offer is, if there is a tenant, if you take out their policy, it's 120 Rand a month, that's inclusive, and you get up to 120,000 Rand legal fees for eviction coverage. And when it comes to, as Zelinda mentioned, loss of income, if you pay 3.5% of your monthly rental. So if it's a 10,000 a month rental, for 350 rand a month, that inclusive, not only will you receive the 120,000 in legal fees, but you will get up to 6 months of rental payment in the event of a defaulting tenant. There's an excess deduction of 50% of the first month. But the bottom line is that for 350 rand, presumably for a 10,000 rand rental in a complex, there cannot be an excuse raised that you don't have the money to do this, because your costs to evict them are covered and your mitigation for finding a new tenant is nullified because you are receiving rental income for a couple of months, which should effectively marry up with the time it takes to evict that tenant. So I encourage you to check it out. And if you want to know more about it, you are welcome. I'm just going to type in the chat line here.
I've already done so, Marlon. It's all there.
Okay, but also if you want to email me directly on it.
I've got your email address and your cell phone number and your landline,
Oh,
Facebook page and your LinkedIn page, everything. On
sure.
the
So
we
I'm just
also
saying
going to put it all on the website.
It's just exciting, and I think there's many ways to skin a cat, going back to the cat analogy, that, you know, if you're looking at the unfortunate situation of a body corporate or a homeowners association having their hands tied when it comes to dealing with an errant tenant, if that property owner or that landowner, as they will soon be called when the Act is finally amended, even though you don't have to be a landowner to be a landlord, think about that. In that particular instance, if they know that the costs of the eviction are covered, because I've never charged 120,000 rand for an eviction ever, but if they know that the eviction costs are covered and they know that their rental is covered for a number of months, why do they not take the opportunity to get rid of that tenant and placate a very frustrated body corporate who can't?
Yeah.
And to end it off, just to go back to it, how do I go back here? So the landlord and tenant relationship within community schemes is more complex, excuse the pun, due to the additional governance by bodies corporate and HOAs. And I think landlords need to comply with the lease agreements and the scheme specific rules and educate those tenants and just have clear communication. You know, be mindful of the fact that it's no longer just your tenant in a complex. It is an occupier of shared space. It is an occupier in a communal scheme. There are many people who rely on those units speculatively for their investments, and they want to see not only capital appreciation, but, you know, the property in itself, the complex in itself, is reputable and respectable, and it can all be destroyed by these tenants who don't pay or who don't listen or who aren't educated. And, you know, even if you have to go to CSOS or employ an attorney, it all comes not even a financial cost, but it takes time away from what you want to do with your life. And even going to CSOS is an exhausting process. Even listening to me talk for 45 minutes is an exhausting process. But the point is that you can't avoid the complexities that come with the landlord-tenant dynamics that manifest themselves in communal schemes. But I think, and as you correctly mentioned, with something like 10 risk or any other product which assists that landlord to deal with that tenant, especially when it comes to non-payment or evicting them, which seem to be the two major issues, I think it is certainly something that should be looked at. And I really commend those who buy units in complexes and speculate on the rental, because ultimately you become an enemy of more than just your tenant when you have to act against them. And I just think that it's such a dynamic beyond freehold. And I think there's more to it than that. And I think there's further webinars to be held on those types of arrangements. And I think that's my time.
Fantastic. Marlon, we've had so many questions on the chat. I've copied a couple of them and maybe we can run through it. But just from me, firstly, thank you for giving a shout out to Chris van Geens. He's actually a kick-ass levy collection attorney, and he is the very first attorney that I ever had any dealings with in practice, like when I started working as a grown-up. And so it was very cool to have a bit of a trip down memory lane mentioning him. And then the other thing that we spoke about was you know, what of the governance documentation needs to be attached to the lease agreement. We know that we spoke about rules, and then you mentioned when we were chatting about what about the constitutions or memorandums of an HOA or the management rules of a body corporate. So when we spoke about it, we said that only the rules that the tenant would need to be aware of should be included. So not necessarily the constitution or the MRI or the management rules. And I've often been asked by bodies corporates if I could provide a abridged version of rules that only highlight what the tenant should be aware of. So I do that with the caveat that That's not the approved set of rules, that you obviously need to look at the entire document as a whole. We are going to share a copy of the recording as well as the slides, and every single link that Marlon has mentioned and the ones that he hasn't mentioned. If you just Google Marlon, the pages are extensive with regards to the various service offerings that he does offer. Just a couple of questions, Marlon, while we have time. Does the Rental Housing Act also apply to short-term letting tenants?
It actually doesn't. It deals with dwellings, and short-term rentals aren't deemed to be dwellings. In fact, short-term rentals are deemed to be a commercial transaction, which means you wouldn't even use the PI Act. You would go through a normal court application in terms of the common law. So yeah, short-term letting is quite an anomaly, in fact. So no, they don't fall within the Rental Housing Act.
In terms of maintenance, who is responsible for what?
Landlord, the external, tenant, the interior.
And obviously very different in bodies corporates with the median line and common property and section.
Absolutely, very different.
Please confirm if the Rental Housing Act requires that the conduct rules of a body corporate be attached to the lease. I think we dealt with that quite sufficiently. We have no rules, and never mind, I'll skip over that one. I do all my leases digitally. Do I need to make the lease and the conduct rules as one document, or can they be attached to the email separately? That's a goodie.
Can be attached separately. What it simply says in terms of section 5, subsection 8, is that a copy of the house rules must be attached to the lease. When I do an eviction or I see an instruction to sue, I want to see that lease agreement. I want to see the defect list, which is the incoming inspection, and I want to see the house rules, if they are, and I want to basically see them as a bundle. So I have no problem. I mean, just to make it even more complicated, is that in terms of the Rental Housing Act, there are deeming provisions. In other words, you don't have to have a lease in writing. You don't even have to have a lease that is, you can have a written lease that doesn't even need to be signed. But so long as there is an oral lease, there are deeming provisions. The deeming provisions are section 5, which says every lease agreement, written or not, there is laws that have to be followed and are deemed to be part of your verbal agreement. When there is the incoming inspection, the outgoing inspection, deposits, etc. Whether you have an oral lease or not. But what I want to see is if there is going to be a lease agreement in place, there at least is an annexure. I'm not saying the annexure has to be initialed. It's better to be initialed. But as I say, even if it's attached as a separate bundle, as long as the tenant is alive to those terms, and as long as there is reference in the lease agreement to the house rules. So as I say, have a good look at your lease agreement. And if you need a bit of guidance or a clause, just to add to your lease agreement that the duties of the landlord, duty of the tenant, where it says this lease incorporates any house rules. There should be a clause like that, any house rules or estate rules or a conduct rules, as the case may be, as part of this lease agreement. And if that's the case, you should also ensure that those tenants look at those house rules. Because again, Zelinda, not to belabor it, but oftentimes there are lease agreements which have simply a link to the rules. You click on that link and you read it and you agree to it. In that instance, it's not really attached to your lease agreement, but it's incorporated by reference by virtue of a link. That's all. I mean, you can, as long as you can show that the rules are known to them and they agree to them.
That takes me back, and I think Rosine and Razar that are online have a little bit more recollection of this than I do. But interpretation of statutes, I mean, when you read the legislation to say attached, you literally should attach it. Let's not try to incorporate too much of the modern technology, because we could actually shoot ourselves in the foot and then end up in jail, which we obviously don't want.
I am at UCT in my second year of LLB. I got the top mark for the essay on interpretation of statutes by Professor Julian Hoffman. It was the literal versus the purposive versus the teleological value-orientated approach. So like legislation, you can't drive more than 60 kilometers an hour. That's the literal approach. Purposive means, well, if your wife is pregnant and you're rushing to the hospital, you can exceed 60 kilometers an hour, because purposively, it was never the intention to keep you at 60 kilometers if you're rushing to the hospital. And then the value-orientated approach, what does society say? So in that respect, literally, you probably need to attach it, but purposively, it might not be practical to attach the rules attached to the lease. A link would suffice, etc.
Especially when there's no lease agreement and you're just chatting to the guy.
So I love that. Yeah. No lease agreement, but there are rules.
Zelinda, can I add some value here?
Yes, Barry, please do.
I'm sorry. Hello, Marlon. Nice to see you again. Just on that short-term lease issue, I've been quite involved with the City of Durban, trying to regulate the accommodation providers, regulation for the Natal or let's say KZN Tourism. And so any lease less than 6 months is now termed to be an accommodation provider, and they need to now be registered. I think Cape Town does the same stuff now as well. Registered with their local community tourism organization, and not run like an Airbnb type operation, which we are finding a lot of the flats and the complexes, obviously in the coastal area of Durban, doing. So those chaps need to now register if they are bringing in tenants less than 6 months. Anything over 6 months, we're back to the section title rules.
Let me just jump in there, Barry, and I hear you. That's a great question, and I know I was involved in providing advice to a number of accommodation providers when the City of Cape Town did the same thing. What you may or may not know is that our law firm, I've got 2 law firms. I don't know if people know this. I've also got a separate law firm, JKS, which is a level 2B law firm. My 2 directors are my 2 senior associates, Marlon Shevelew, and we do work for the City of Cape Town. But and we've learned a lot of the regulations. It's amazing. But Barry, just touching on that 6-month lease, in terms of the Consumer Protection Act, that would be a fixed term lease. So in fact, if that is a fixed term lease, it's a fixed term transaction. Even though it's a 6-month lease, the landlord would need to give 20 business days notice. If the tenant wanted to terminate, they could give 20 days notice, and they're out of there, subject to a reasonable cancellation penalty. So it might not fall within the rubric of the Rental Housing Act or the Sectional Title Scheme Management Act, but it would certainly have implications for the CPA. So I'm just saying that the CPA has buggered up everything totally, but it just makes it very, very interesting. But thanks, Barry. Nice to see you again.
A pleasure.
Barry, we must pick up on our conversation that we had. I think you were just about to go into hospital, or you were in hospital when I asked you to do a webinar for us. And I think the short-term letting issue might be something that we would be very keen on hearing about. So I'll touch base with you offline.
Wonderful. Thank you, Zelinda.
Awesome.
Just to add in quickly, when we have a long-term lease, when I evict somebody, that's called short-term letting.
You have made a couple of real funnies today, Marlon. Thank you so much. Ladies and gentlemen, no worries. So I know that we have just exceeded our time, but I would like to offer the opportunity to anybody online to ask 1 or 2 questions if they would like. Marlon, if you've got a couple of minutes for us.
Of course I do.
Perfect. So if you do have a question that you'd like to verbally ask, you're more than welcome to do so. Just a reminder, pop up your hand or put your camera on, unmute yourself, and then you are more than welcome. I see that we've got our first, I'm not even going to try to pronounce your name, Motla. Can you please unmute yourself, and you're more than welcome to ask your question. Just wait. Unmute yourself. And then Annette, I see you've also got your hand raised. Maybe Annette, you want to start along?
Yes, good morning. I put it in the chat, but I was very interested in this thing about the notice the short-term leases. But now, if the lease is an annual one, I'm actually a trustee. Is there an obligation by the owners to actually notify the managing agent and the trustees that there's going to be a change of ownership, and who and details of that?
Yeah, Zelinda, I'll let you answer that. I think
no problem. No problem. So yes, it is a requirement that the owner advise the body corporates of any change of ownership and occupation. And it is the owner's responsibility. And of course, if the owner has a rental agent and has delegated that to them, they would need to notify the body corporate. Very often, the body corporate gets notified of any change of occupation from an ownership perspective by the transferring attorneys. But with a rental obligation, it is the owner or the rental agent, but essentially the owner. And we often find that with schemes that have some form of biometric access control system that you have to register the tenant, that is often how the body corporate becomes aware of a change of occupation. Another issue which Marlon and I did discuss offline was for short-term letting, when does that owner notify the body corporate of a change of occupation? Because a booking could happen in the morning and the person could come in, at 2 o'clock in the afternoon. So a very good question, Annette.
For the long-term lease, I mean, I just, because I find that there's a very dark area between as a trustee, we've got a managing agent, but we have very little information or links or communication with the owners, and very often it's over occupation and all sorts of things. It's as if it's been kept away from the managing agent and from the trustees.
Yeah. So if
can there be any kind of protocol or something that can be set in
Yes,
place?
yes. You most certainly must put protocol in place. What we do in our rules is we actually attach a form to our proposed conduct rules dealing with owner and tenant information, including things like start and end date of the lease agreement, the number of occupiers, who the occupiers are, vehicle details, all those fun things, even if there isn't an access control system that needs to be loaded with the information. And it's also a very good reason that a lot of body corporates require a copy of the lease agreement once entered into as well to have this information. And if it is a requirement in terms of the rules, which it is, the prescribed management rules or your amended conduct rules, then a body corporate can raise fines for that non-compliance. So you should definitely have a procedure in place. Annette, I'm just going to move over to Motler that had his hand raised. Just remember to unmute yourself.
Hello.
Hi there.
Hello.
Sorry, you were muted again. Motler, just unmute yourself. Here we go. Got you.
Good morning. How are you? How are you?
Good, good. Thank you.
No, very well. Thank you. Thank you for the nice presentation. I think when I saw this invite, I saw an email and then I just followed, and then I must say the information that was shared is very informative. So my point now is I'm a trustee where I'm staying, and then where I bought a flat. So, and then with that, I have a trustees in a way that the trustee, one of the trustees works for the very same managing agent that manages our complex. So what is happening now is most of the time, because I think I'm one of the owners who stays there, otherwise everyone is just a tenant. So most of the time I will guide issues, things that the tenants are doing, and then others will be charged and everything, letters will be sent. By then they have this thing of, I didn't know at first that who was the owner of that complex, of that flat, only to find out when I raised something, because like we have the house rules whereby no washing lines should be outside of inside for facing the public and everything. So when I started looking at the rules, after they took the schools to the CSOs, then what we did, I started noting it out, and then they started sending out letters. By then, this flat that there is one of the trustees, like this week, I sent out an email asking them, guys, I've been seeing letters for other units, but then this one I haven't seen. They said they're doing it internal. And then I was like, what is internal? Because the managing agent works for the trustees. So if they do anything, if we have to see all the letters for everyone who's misbehaving in the complex, we should be able to see those letters.
Yes,
So
yes.
they said they're doing it internally. So, and then this week they even started to change the group, the WhatsApp group, because that way normally I will go into, if there's a water running, I will just send a picture, guys, this is what is happening. If there's a noise, I'll just take a picture, guys, this is what is happening.
Yeah.
And now they changed the group. It's no longer, it's only the admins who can send the message in the group. So I'm not sure how I should really deal with that, because like now I think they're trying to bulldoze me or something.
Yeah. Yeah. So it's not necessarily related to the topic per se, Motler, but I'll give you a little bit of quick advice. You know, as a trustee or as an owner, you're entitled to all of this types of information. And a lot of managing agents or trustees will raise the argument of, oh, it's contrary to POPI. And I know, Marlon, you've got a lot of information about that as well. But in terms of the Sectional Title Schemes Management Act, an owner or a tenant, an owner or a person authorized in writing by an owner, of course, a trustee as well, does have the ability to access this type of body corporate information. Also remember that a managing agent cannot be a trustee unless that managing agent is also an owner of a unit in the body corporate. So that's something important to remember as well. And the managing agent is not a decision maker either. I'd be more than happy to chat to you offline a bit further if you would like. I'm just going to ask if there's anybody else that would like to ask a question related to Marlon's chat. If not, Marlon, I thank you so much. I learned a hell of a lot today, which is great. And it was really, really awesome to have you online. Kyle is going to check with you to make sure that we have every single one of the relevant links, and we are going to make sure that that is posted along with the slides and a copy of the recording as well. And then, of course, Marlon, you are welcome to use it and at your discretion as well. I'd just like to use this one opportunity just for two last things. Number one, I'd like to formally introduce Rizal. He's our latest team member that has joined us. Interestingly, there he put his camera on. Hi, Rizal. Rizal is a practicing attorney, and he is still continuing in practice while working with us as a consultant. Rizal may have dealt with a lot of our managing agent clients previously in his role at STBB Attorneys, along with Razine as well. We like ourselves some STBB attorneys, and we just welcome him to the team. Rizal is interestingly residing in the UK, which is amazing because it really does show that we are able to do what we do remotely. For those of you that don't know, all of our staff members live all over Cape Town and now the UK as well. So it's really great to be able to always be in touch remotely. And then one last thing, I just wanted to ask Mike Addison, are you still online? I just wanted to ask you a question about the insurance. Mike, I see that you are online. I'm going to give you a second to unmute yourself if you're able to.
Yes, hello.
Hi, Mike. You know,
Marlon, well done.
I always feedback on you. So, Mike, we chatted about loss of rental and alternatives accommodation and anything like that. Do you have any advice to offer any of the guys that are still online?
Yeah, so the loss of rental from an insurance perspective is when there's damage to a building. So it's not really got anything to do with, losing a tenant or anything like that. Only when there's a fire or an event where the place is untenantable and now there's a loss of income. And we're insuring the owner there. We're not actually insuring the tenant anyway. So it is a little bit of a different one. Just a pointer though, generally I think it's some very interesting points. I mean, Marlon, you've opened a way, or doors open, the sluice gates, I suppose, for many more webinars on a very range of subjects. Just for example, pending the liability comes into it more so than the loss of rental. What happens if a tenant now doesn't get a set of the rules and they go and drown in their child, or their visitor's child drowns in the HOA swimming pool attached to the body corporate, blah, blah, blah. There's a whole lot of ramifications here. Yeah, well done. You've really done well today.
Yeah, no, but sorry, Mike, firstly, it's nice to hear from you again. I think it's been over a decade since I chatted with you. But yeah, no, it's interesting about public liability. Obviously, it would default into the common law. But anyway, that's for another day. But I just want to have one more thing to say before we end off. I just wanted to thank you again, Zelinda, and your team, your ever-growing team, for bringing me in. And it was nice to see a few familiar faces. Some people who I don't really communicate with because I'm more involved in the rental arena than the sectional title arena. But I think what's nice to know is that they are invariably, they're irrevocably intertwined in many respects. And I'm glad I got an opportunity to talk about this dynamic because I don't even think it's been done before. So I'm indebted to you for this. And again, thanks to everyone for helping me get out there, and Carl for the introduction, and for helping me put together this presentation. And Zelinda, you're an absolute legend in the industry. Don't ever say that I'm the expert. You're the expert. I consider you to be the star. So I'm really thankful for our mutually beneficial relationship, and I look forward to working with you and the rest of you guys as soon as possible.
Thank you so much, Marlon. And thank you for introducing us to Cape Talk, that I've also got a little spot in the limelight. I'm very, very grateful for that. So consider this a thank you for that. All right, ladies and gents, thank you so much for joining us. As a reminder, the session's recording will be made available on our website. And I will make sure that we have all of Marlon's contact information. And Marlon, the links to all of the case law that you spoke about, Carl's also going to ask you for that to put onto the website as well. And we'll most certainly be in contact with you again. And yeah, thank you for the time. Thank you so much, everybody. Have a lucky day further and a good weekend. Keep well. Bye.